Actually, there's also a question. Oh, sorry, there's a question if the PowerPoint will get shared out as well.
We
I
can share
love,
slides
yeah,
now. Yeah.
yeah, that'd be great. Thank you.
All right. So our objective today is to help you all as agricultural advisors, or in some cases producers, build stronger networks and better understand water rights for supporting small scale and historically underserved growers. And so my plan here is to give some context to Western water law and Western water rights, talk through some water right basics, and then talk about, well, what if I don't have a water right? Then what can I do? What are my options? All right, so we'll kind of dive into just very high level Western water, what the challenges are, what the context is. And it's helpful to think about, of course, the West or the rest of the United States in terms of watersheds. So we have this beautiful map. And aside from being stunning, it really does show US watersheds, right? And watersheds are a defining unit of the landscape and are really critical for how we think about water, water rights and water management. You can see the Columbia Basin here. Can you see my cursor?
Let's see. Yep, we can.
Okay, perfect. So the orange is the Columbia Basin. Obviously, this light pink is the Mississippi. We have the Central Valley here. And we have lots of other watersheds as well. Sorry, the clicking through is very sensitive. All right, so equally important to understanding Western water law and Western water rights is precipitation. And here we have another pretty map showing precipitation patterns. And precipitation governs a lot of what happens in those watersheds and the consequences for the laws and policies that have arisen to manage water, and especially how that burden of scarcity is shared or distributed. So we'll get into this a little bit more as when we talk about the legal frameworks for water rights. But certainly, these areas, water law is based on the aridity of the West. And so we do have many of you here representing areas and working in areas that are west of the Cascades. We're still working with the same water rights framework that we do in the rest of the arid West. So we'll talk a little bit about some of the tensions there in a minute. Now, kind of moving away from the natural realm into the human realm, each of these dots equal 10,000 irrigated acres. There's a ton of patterns here. You can see that we have a lot of concentration of irrigation in eastern Washington, southern Idaho, the Snake Plain area, of course, the Central Valley of California, spread throughout Oregon. And, there's certainly, I won't focus too much, but you can see patterns of irrigation in the eastern US as well. All right, so some of the things that Western water management is challenged by are kind of highlighted here in the blue. And over allocation, water availability is a huge one. We'll return to this idea that most of the watersheds across the West are over allocated, meaning there's more water rights on paper than there is actually available physical water. Certainly another defining characteristic of these watersheds is groundwater depletion. And we've seen rapid groundwater depletion in a lot of different areas across the West. We have a very old system of infrastructure. In some cases, we have wooden ditches, concrete pipes. These things are expensive to fix, and in a lot of cases have not been modernized. And of course, we have to mention climate change, changing precipitation patterns, decreasing snowpack. All of this, this is not exhaustive, but it's representative of a lot of the challenges that are facing our watersheds and our water management agencies and our growers and our producers. Okay, I want to briefly shift to Indigenous water use just for a few slides here, and certainly acknowledge that when we talk about land and water in the West, we're talking about resources that were taken from their original owners and for which little, if any, compensation has ever really been provided. But before we talk about water rights from the perspective of non-Indigenous folks, let's just talk a bit about water for tribes. And this map shows Indian reservations today. It's not exhaustive here, but it's a snapshot here. And of course, tribes and reservations, as well as ancestral territory, are a major feature on the Western landscape, and correspondingly, a really major feature in water use and water management. Okay, so the water rights of treaty tribes are senior to all other uses. However, the ... is that some tribes have negotiated water rights settlements, and some have not. And so in most watersheds, while these water rights are theoretically senior, they have not been quantified or enforced. This map shows in green the areas where tribes have already negotiated water rights settlements. And this means that water rights have been quantified and recognized, and that they're part of a state water rights system and regulated alongside other rights in their respective states. And I think there's a few new ones coming in, but you can see kind of the pattern here of negotiated water rights settlements. And an important concept for Indigenous water rights are, are so-called winters rights. The Supreme Court said in 1908 that the concept of a reservation as a homeland for Indigenous people includes water rights. Importantly, though, these water rights don't just appear. Tribes work with the U.S. to advocate for these, and then the rights either need to be part of a settlement or an adjudication. So they're not self-actuating, they require legal action and adjudication. Yeah, and finally, before we leave this very brief overview, Indigenous water management, of course, is about more than water rights. Importantly, a lot in the Pacific Northwest, it's access to traditional hunting and fishing grounds, but also access to water for many different out-of-stream uses as well. And can include flow in rivers to support fish and animals that tribes depend on. Okay, so now we'll shift to talking about water rights and prior appropriation and the legal framework that we have to work with, for better or for worse. So why do we even need a legal framework? Well, water has long been defined in the Western United States as a public resource. That means it's a usufructuary right, a right to use a public resource. It makes it a very specific type of property right. And it means that when water is scarce, there's competition for those resources. So we have a system in place through prior appropriation and a few other legal frameworks, which we'll talk about here in a minute. And so we need these rules about how to access it, because there's generally, during a lot of times a year in various watersheds, not enough for everyone. So those legal frameworks include quantifying the amount of water that folks can use for different uses, and they have requirements for use and access, as well as elements of what can and cannot be changed. Okay, so there's kind of four main legal frameworks for water rights that are worth mentioning. Prior appropriation is underlying because that's the one we'll focus on the most, and it's the one that you all need to know something about in order to understand water rights and work with them. But certainly in the eastern US and in some places in the West, California notably, there's a few in Washington, they're very rare, but there are riparian water rights, which follows the riparian doctrine. And that is about access to water depending on your location and being adjacent to water body. So there's no ownership of the water. It's just that you happen to be located in a place where it's where you can easily access that water. And the general rule for capture, rule of capture, is that the first person to capture such a resource owns that resource. It has been adopted by a few Western states. Correlative water rights refer to rights of landowners over a common groundwater basin. This is relevant in the California context where correlative rights are shared equally amongst users. And so I have this table here to kind of compare and contrast the various legal frameworks for water use. And importantly, I think prior appropriation, like I said, is the dominant system. But just for those that are interested, here are some of the differences between how rights are obtained in the four legal frameworks and quantified, and how the burden of scarcity is managed. So prior appropriation follows this strict priority system, priority dates dating to when the use began. Riparian doctrine follows reasonable use in terms of managing scarcity. Correlative rights reduce all water rights proportionately. And there are certainly some water rights in the West that are managed with kind of the correlative system. All right, so prior appropriation, we have this kind of funny slide here, but it's based on adjudication and permit-based processes. That's how you obtain a water right. Water rights have to be used beneficially, and each state defines what beneficial use is. Examples of beneficial use could be irrigation, could be domestic use, could be municipal, industrial, could be fire suppression. There's a whole long list of beneficial uses, could be in-stream flow uses. And the burden of scarcity, like we said, is strict priority, so strictly by the priority system. So this picture here represents senior priority to lower priority, right? So the folks at the end that are senior, they will get their water rights first when there's a shortage of water, and the junior water rights will get a portion or no water rights during times of scarcity. So it's often referred to as the first in time, first in right system. And you may have heard that, meaning that the priority means that if there's not enough water in the system, then the senior water right holders with senior priority dates will get served first. And junior rights could be curtailed during times of shortage.
Amanda, we do have a clarifying question here that might be good to address, but I'm a little confused by it. So Trevor, if you're able to come off
Yeah, I
mute.
wasn't sure how to word it. I was just wondering if beneficial use is ever used. I know it's a strict priority system about date, but if beneficial use is ever used in ranking as far as like who gets curtailment or not, as in like is food production ranked above golf course irrigation?
That sounds logical. I have never heard of that happening before because it's all under irrigation generally for all three Western, Pacific Northwest states that we're talking about here. So there could be a case where what does happen is that during times of scarcity, during a drought, during the summer months, which happen every year, sometimes surface water rights are curtailed, which usually include irrigation, which could be a golf course or could be a farm. And domestic groundwater rights are allowed to keep pumping. And so that's one particular case where there's surface water is being curtailed and groundwater is not. But certainly there's a lot of examples of conjunctive management, and increasingly so, where surface water and groundwater are managed together. And the impact between the two is recognized legally. But generally, no. I have that sounds logical, but not aware of any situations like that happening. Thanks for the question. Okay, so just a little bit about the history of prior appropriation and water rights in the Western US. Each of the Western states passed a water code in the early 20th century. And from this day forward, that required water rights for anybody who wanted to use water rights. So you had to have permission from the state, and it's generally, if it's not clear already, water rights are administered at the state level, not the federal level. So you had to have permission from the state to get a water use permit. And so on the Western landscape, you do have situations where water is moved very far distances from a field or to a field, or to a home, to a city. Farmers in generally 1850s-ish adopted this approach that was used by miners, posting signs at river diversions claiming their use for water. And this is before the water codes were adopted by those Western states. And these claims contain the date when the farmer first put the water to use. And so that is a history of priority dates, is literally these things like a piece of paper posted on a tree saying, I claim this water. And priority was given to earlier claims over later claims during times of scarcity. Like I said, post 1900, all Western states, with the exception of Colorado, adopted a permit-based water rights system where you have to have an application that goes to the state to have a water right. All right, so next, with that kind of context, we're going to move to elements of a water right, how to find out more information about a water right, and how to conduct due diligence on a water right. Okay, so there are generally 3 types of water right documents. Claims, think of it, that piece of paper posted on the tree, is an assertion to use a specific quantity of water for a specific beneficial use. Water right claims are generally not issued by the state, but they're often intended for water use established before the adoption of the state's water code. And they may be adjudicated later by the state. So a water right permit is issued by the state if generally the applicant files a water right application, and then it has to be, depending on the state, it has to pass some sort of legal availability test. Often you have to prove that there's not impairment to other water rights or third-party uses. And then it gets approved by the state agency. And then certificates, a water right certificate is issued once a water right permit is perfected, meaning perfected means to put all the water under the water right to its full beneficial use. And water right certificates describe, and I'll show you some examples of that, all the attributes of a water right, and they're assigned a priority date, like we talked about, which is the same usually as the application date. Yeah, I'll just leave it at that. Okay, so wet versus paper water. I just want to call this out. This is when we're talking about beneficial use, we're talking about beneficially using water. And generally the type of water we're talking about here, the beneficial use we're talking about is irrigation water. So generally in Washington, Oregon, and California, you have to use your water right at least once every 5 years. And you have to use it for its beneficial use. So I think this is one of the misunderstandings of water law that pervades a lot of the water right context, and that folks think that if I just turn my pump on, or if I just start diverting water from the stream, I am showing use. But spreading water and not irrigating an actual crop, it does not show beneficial use. And so when we go through kind of the evidence of irrigation, you can, the state agency can really tell based on aerial photos, meter records, power records, cropping records, whether or not a water right was beneficially used. That said, it's rare that a water right, any water right on the ground today reflects the exact same conditions as it was certificated or permitted. All right, so here's an example of a water right. It's in this antique font here, you can see. Sometimes it's hard to read, but you've got the source of the water right. You've got the priority date. This is 1865 from Catherine Creek. You got a total volume limit, 3 acre-feet per acre. You've got a rate limitation, which is expressed in cubic feet per second. You got the diversion location, legal description of the diversion location, and you got the legal description of where the land where it can be used. You could think about this as the water right footprint, right? And these are all really important elements. That said, not the actual use doesn't always match what's on paper, right? But generally, these are the elements of a water right that are really important to look at, whether you're looking at that for yourself or somebody you're working with, and try to understand, well, is the water used, are they using the source on the water right? Or are they diverting from somewhere else? Are they using the same amount? Are they irrigating in the same location, or is there change? And there are elements of this that can be changed, but generally it's important to look at the original documentation to understand what's permitted. Okay, no two water rights are the same. Even within a single state, there's variations in format and content. Some of them have special conditions on them, like maybe something like when stream flow drops to a certain level, you have to change the way you divert, or you have to stop diverting. That could be an example of a special condition. Some of them have missing information and they don't include, say, a rate, or they're very vague and they just say a spring or an unnamed tributary. So all of those are variations that I've seen and in researching and working with water rights. So we talked about the water right footprint, the point of diversion location. This is a really important piece, and I'll show you some examples here. Is the water diverted from a ditch or from a pipeline, or is it from a well? These are all important elements to keep in mind. And what's the water right priority date, and how is that compared to other water rights priority dates of the same source? That's another element. Like the example that we showed on Catherine Creek, okay, it was 1865. Is that senior, junior, in the middle compared to other water rights on Catherine Creek? All right, here's an example of a place of use. Most of the Western states have a website where you can go and take a look at the water rights, and they have kind of a mapper, which is an improvement. They haven't always had this, and they're imperfect, but they show the legal place of use, where the water right can be used. This one is highly specific here, and kind of sometimes it's just a polygon, or just a sort of a square shape or rectangular shape. They vary. The point of diversion, also known as the POD, in this example, you have multiple points of diversion, and this is common. So you may have points of diversion, multiple points of diversion on the same water right. This is Waichus Creek, tributary to the Deschutes in Oregon. This may be represented by multiple water rights, or one water right could have multiple points of diversion. All right, so for surface water rights, which are from a stream or a river, they oftentimes have a head gate or a diversion location. If it's a larger water right, they're going to have a head gate. This is a picture, an example of one that's kind of manually operated. If there also can just be a pump in the creek, if it's a small diversion, and there may not be any sort of ditch system in place. All right, so let's talk about how do you find out information about water rights, and why is that important? And that's due diligence. You're doing your water rights due diligence. And I think that's probably particularly relevant to you all, and to conservation districts professionals, for example, of figuring out, okay, well, I want to know, does this property have water rights or not? And what do I know about those? And are they beneficially used? And what about the new landowner who comes in? What can I tell them and advise them on? So water rights due diligence is a structured, replicable approach to assessing the validity and eventually the quantity of water rights. And the state certainly does this, but practitioners can do it in the field to improve their understanding of water rights. Water rights certificates memorialize a water right as it was proven up, at the time that it was issued. Here's an example here of a piece of property, and you've got surface water rights and groundwater rights, and you have overlapping places of use, and it's kind of complicated because you have the parcel lines, you have the surface water right boundary lines, you have the groundwater right boundary lines, and none of those perfectly align, right? One thing I think that's worth pointing out here is that water rights are appurtenant to land, meaning if you sell a piece of property and you don't specifically exclude the water rights will transfer to the new owner of that land. However, there's generally not a system in most states where the name on the water right gets changed. It's still the same one that was written on that ancient old document, the same original water right holder name. So water right, that's just a complicated way of saying that water rights don't track with parcel name changes. So that adds to confusion, but it's, just how the system is right now. Okay, so when you're thinking about evaluating water rights and doing your due diligence, you want to take a look at your aerial photography, right? And you can do that using Google Earth. And you can also do that using, this is an example in Washington State, where you can use the Water Resources Explorer website, and we'll provide links to all of these websites too. But you can use this to show the place of use of the water right with aerial photography. So checking the state water resource database is usually your first step. You can check county online parcel maps. Some counties have really good GIS systems that they don't necessarily have water rights, but it's important to understand how the water right boundaries overlap or don't with parcel ownership. And you want to locate the point of diversions, the place of use, using those kind of the water rights databases like this one from Department of Ecology in Washington. Okay. All right, so here's kind of a snapshot table showing all the steps of water rights due diligence at a glance. So we've got our water rights inventory. So you want to consult your state agency online resources. You want to do kind of a historic use assessment, because water rights are only as good as their beneficial use. If they haven't been used, they may not have any value at all to a future user. So the historic use assessment includes how and where water has been used in the past. And you can find this out by talking to the previous landowner, neighbors, state agency employees. Historical photos are often a really good indication. You can see what kind of cropping and irrigation patterns. You can see a lot from aerial photos. You could use OpenET, which is a recent tool that's been developed to look at evapotranspiration. And that's available. You can look at regulation of water rights in the past on a particular stream and ask state employees or neighbors, has this water right ever been curtailed, or has the state ever said you couldn't use the water? You want to look at the infrastructure and assess the condition of the headgate and the ditch. Does it look like it's actively being used or recently was? And visually inspect it. If you're wondering, is there a history of irrigation use, you can look for just irrigation equipment on the property and try to understand what the pattern was. And while there can be some trepidation about talking to state agency folks, I think you all have a good sense of in your particular areas whether there's someone that could be helpful or not on understanding water rights. Okay, let's just pause there, see if there are any questions. We're going to go into we still have a little bit more here on due diligence, but any questions or observations so far?
Thanks, Amanda. I think Diane had a question a little bit ago that got to you answered some of her questions, but Diane, if you're in a place where you can come off mute and ask any additional questions, particularly around the irrigation districts, that would be great.
Sure. To rephrase that, and thank you for all this information so far. To rephrase that, I'm just wondering how the first in time, first in right applies when you start to have irrigation districts that came into play. I know that if properties had come with a predated water right before the districts were formed, that generally takes precedent. But what about those properties that have received their water rights through the district? My understanding is that that order of priority mainly happens in terms of geography, who's closest to the point of diversion, they get their water first, and then it goes down the line, and then also who makes the most noise.
Yeah, so thank you for that question. Irrigation districts have water rights, right? So they have a water right that has all those same elements that we just talked about. But their place of use is usually really large, and there's a bunch of different parcels underneath it. And then they have a ditch system, or maybe they have a modernized pipe system where they're delivering water to different landowners within the boundaries of the irrigation district. So irrigation ditches are curtailed just the same as any other individual water right, and based on their priority date. It's usually up to the irrigation district to, I mean, say they're usually diverting 10 CFS and then they get curtailed down to 8 CFS. They have to figure out within their own district how they share that burden. So there's not that necessarily a formal way. It could be, well, where can we physically get water to because we have leaky pipes and we can't get it to the end, like you said, so proximity to the point of diversion. They could also set up other priority systems. And I think it really depends on how the irrigation district is managed. The state doesn't tell them how to share a shortage of water during times of scarcity. So does that get at what you were thinking about, or is there more?
It does. I think it very diplomatically answers that it's still kind of in control of the districts, and how transparent they are with that process is going to be dependent on the district.
Absolutely. Yeah. How transparent they are. I think they should have they're required to have meetings, and any members can attend. So I think that's a good opening. If you have landowners within an irrigation district, getting involved with the irrigation district, either as a board member or just attending board meetings, is a really good way to advocate for water needs, and understand how water is allocated. It's probably worth mentioning too that there are irrigation districts and irrigation companies, and they are governed differently. Irrigation companies are like special purpose districts, and they generally have shares in their water right that they sell to landowners, so your allocation of water is dependent on how many shares you have in a company versus the districts, which are public. They just are supposed to serve everyone. But often they don't have enough water to serve everyone.
Thanks, Amanda. We've got another question from, I believe, Letitia. If you want to come off mute and you're able to, feel free. If not, I can ask it for you.
Yes, I'm here. Thank you so much. I'm sorry if it's a little off the point you're on right now, but I'm picturing water that doesn't come through pipes that you described, or a stream going through, or some kind of a controlled system, but rather just a well on your own property. So does that have rights like things tied to it?
Absolutely. Yeah, thanks for bringing that up, Letitia. All of these elements that I'm talking about apply to both surface water and groundwater rights. So groundwater rights are associated with a well. Surface water rights are associated with a stream or river as your source. So you still have a place of use. Your point of diversion is much more straightforward, right? Because you're not moving that well around. So you're pumping water out of the well from that specific location, and that doesn't change. And then you are permitted to use it for a specific use at a specific location, and you have an amount. And in terms of how the quantity is measured, usually the annual quantity is measured in acre feet, whereas the instantaneous quantity is measured in gallons per minute instead of cubic feet per second. So that's one slight difference, but there's still an instantaneous and an annual rate for water from a well. All right, any more questions before we?
That's it for now. Yeah, and we'll get into a little bit more around the well water rights, correct? In a little
Yes,
bit.
yeah,
Yeah,
we'll talk about exempt wells.
great,
But
perfect. Yeah.
all of this, everything we're talking about here also applies to groundwater rights.
Great.
Yeah. Okay, so a few notes on aerial photography review. And I think this is, yeah, this is a really important part of understanding water rights that you're working with or evaluating a property that you're working with. A couple notes on the west side of the Cascades, in wetter areas where we have a bit more rainfall, farms can look like they're green year round. So usually when you're doing an aerial photography review, you're looking for something that's green and therefore irrigated. However, say in the King County area, something might look green on an aerial photograph, but not actually be irrigated. So that's an important distinction. August or late or kind of early September photos are more reliable. And it's great to look at the particular property you're interested in relationship to nearby fields where you might see, maybe you're going to see a center pivot and you're going to see a circular pattern, or maybe you can see that there's flood irrigation and therefore it's kind of blotchy, but there's bright green patches. And so you can look at that field shape and the field texture to really understand whether the ground is likely receiving irrigation. Here's an example where we think, oh, this is probably some flood irrigation over here. It's a little bit patchy. Okay, so where to find water right information? Generally, like I said, Ecology, Oregon Department of Water Resources, and the California e-worms databases. Each of these state agencies has their own lookup tool that are relatively helpful. You can also, sometimes there's field offices that you can ask about information. And I mentioned this before, but really neighbors and past property owners are really an excellent source as well, because they can tell you, oh, they've always irrigated those raspberries, or I've never seen them pump water from there. And they can be really helpful. If there's a ditch system, like we were just talking about, talking to other water users on the same system can be really helpful. Okay.
I just had a quick question. This is Ashley. Does anyone know what the one is for Idaho?
I can find it. Yeah. Let's find it and share it. I do have, let me see, I have all the Oregon, Washington, California.
I have been sharing the link to that document, Amanda, with all the Oregon, Washington, and California ones, as well as these kind of bullet points of what you can do, because I feel like this slide is like the slide for our folks here on the call.
Awesome. Okay. Yeah, well, we'll find the Idaho one. Maybe somebody will find it before we're done here and pop it in the chat. Okay. An important part of understanding water rights is if you're talking to the current landowner who's hopefully owned the property for a period of time, you can ask a lot of questions, right? There's a lot of key water right questions. So if it's a groundwater well, you want to know where the point of diversion is, go take a look at it. Is it functional? What's the type? What's the model number? Horsepower. What's the horsepower of their pump? The capacity of the pump. Do they share the well with anybody else? Do they have any kind of measuring device, or do they keep any records of when they've used the well or how much they're using? You want to know what crops are they irrigating, because different crops use different amounts of water, of course. Have they had any annual changes in crop type? Do they have any cropping records available? That could be seed receipts, it could be records of sale. How many acres are irrigated? Has this changed over the last 5 years? This is important. There's nothing, most farmers change crops and rotate crops, and it's important to kind of note that. And when do they irrigate, right? Do they start on May 15th and turn off on September 15th? Do they start in July and turn off in October? Do they irrigate every 2 weeks, every day, only when water is available? If so, when's that water generally available? So really honing in on a lot of these details will really help you understand the water right. And what method of irrigation is used, right? Are they using wheel lines, hand lines, drip, micro sprayers? Has this changed in the last 5 years? All of this will give you a much better understanding of what water was beneficially used, and allows you to do some, we're not going to get into the water math here, but it allows you to do some calculations and figure out how much water is being used consumptively and how much is being used non-consumptively. So consumptive water use is the water that is evapotranspiration, so water that is taken up by the crop and water that is evaporated. And non-consumptive water rights, water is water that is associated with bringing water to the field. For example, a ditch system, you have to divert more water from the creek than you actually are using on the farm, because you're going to lose some in the process, right? Or you're going to lose some in the application, the irrigation efficiency. And the more inefficient your system, for example, flood, which is the least efficient, the more non-consumptive water you need. And so generally, there's a consumptive and a non-consumptive element of each water right. You have flood irrigation, which might be 50% efficient, versus drip irrigation, which is 90% efficient. And so understanding those different elements of water use really gives you much more insight into how to understand beneficial use. And so beneficial use does include non-consumptive and consumptive. In terms of moving, like selling water or marketing water, usually that's based on consumptive use, which is calculated by looking at the irrigated acreage, the irrigation crop requirement, and the irrigation efficiency, as is listed here on the slide. Any questions on that?
We've got a question from Nat here. Nat, if you want to come off mute, if you're able to ask your question, that would be great.
Oh, yeah. Hi. I was just curious, these kind of assessments you're talking about right now, especially the landowner interview, is this just kind of the process, or part of the process for due diligence? Like, are you just going into deeper review of that?
Yes, I would say that is under the umbrella of due diligence, and having a landowner interview is a really big part of due diligence on a water right. Yes.
Thank you.
Yeah.
That's it for now. We did track down a couple of options for the Idaho research on water rights.
Awesome. Okay. Okay, so there's some things you can change about a water right and some things you can't. So you can change a place of use or a point of diversion, either temporarily or permanently. And this is just generally across the board. It's not, you still have to get, you have to apply to the state agency for a change, and then you have to get approved. You can change, you can do an in-stream transfer or lease, and we've got some summary there. That kind of depends on state law. It's easier to do it in Oregon, Washington, Colorado, and California. It's possible, Utah, Idaho, Montana, Nevada. Idaho, it's much easier in the salmon than elsewhere. Challenging in Arizona and New Mexico, and could add quite challenging. Some states change, you can sort of change use of conserved water, whereas like if you become more efficient, for example, then you could make changes to that water. And when the state is, you could also change, I guess it's not on here, but you could change the type of use, but it really depends on how that water was used in the past. So if you're, for example, If a city wants to buy an irrigation water right, irrigation is generally not used year round with some exceptions, but generally it's used during the irrigation season. That can be really problematic to go to a year round domestic use. So that's an important element of change considerations. When a state agency is evaluating whether something can be changed, they do an injury analysis and looking at will the change to a water right lead to any kind of legal injury to other water rights, meaning that a water right might not receive the same amount of water that they used to receive or they're legally entitled to. And they'll look at do an analysis of return flow, which is the water that returns. Remember, we talked about consumptive and non-consumptive water. Return flow is the water that kind of is non-consumptive and trickles back to the aquifer or to the stream. And you can assess that in a kind of a historic use analysis or water right due diligence that the state performs. Okay, so this is kind of my key takeaways on water rights due diligence, and that no two water rights are alike. So just because you've seen one doesn't mean the next one you look at will be remotely similar. Well, I think this is a lot of information. I think don't be intimidated. You can understand more about water rights just by spending a little bit of time and looking them up and asking some key questions. And that water rights due diligence that we talked about is a key part of the process. The best sources, those state websites, I should say, as well as any state agency personnel that you feel comfortable reaching out to, past landowners or sellers, and neighbors or others on the shared system.
Thanks, Amanda. This is a great key takeaway slide. I'll say we've got a few questions coming in. In terms of the due diligence process, Diane Fish was asking, what do you do if the landowner's dead and their heirs have no clue about what was happening with water rights use on the property?
Yeah, it happens a lot. I've certainly seen that situation. Well, it really helps. You could go onto the property, with the new landowners and take a look. Is there any irrigation infrastructure? Or do you see a pile of pipes laying around? Do you see a pump in the creek? Do you see a well? You're going to look at aerial photography. So before you visit that property, you're going to look up and see if you can find any water rights associated with the property on the state agency website. Then you're going to look at the aerial photography and notice, oh, this field is always really dry in the summer. Maybe they're not irrigating. Or look, it looks like they're growing corn. I can tell that from the aerial photography. You're going to, so you do those steps where you look up the water right, you look at the aerial photography, you bring that out on your site visit, you're looking around for any kind of infrastructure, and then, you talk to the friendly neighbor or something, and you can ask, do you remember seeing sprinklers or a crop grown, or were they haying this property? And usually the neighbor will know. So I think even if the landowner is nowhere to be seen, there are many things you can do to better understand the history of water use, because the future of water use depends on the history of the water use.
That's super helpful. And really related to that, Ashley was asking, do you need to have a lawyer for any of this initial kind of research of water rights, and any advice on that? Like, I'm imagining as you're going out to the site, for example.
I would say no. I mean, researching the water right, looking at aerial photos, I think those are all things that are worth any of the folks on the call doing on their own. If there's a legal dispute over the water right or something, obviously you want to retain counsel, but generally just doing the research could be thought of as any other part of any sort of technical services conservation transaction. If you're going to make a change to a water right, or you want to figure out, well, I don't think this has been used for 5 years, but maybe there is some sort of exemption and there are exemptions for non-use of water rights in each state. And I didn't get into those because it's state dependent, but examples of exemptions, so the 5-year forfeiture statute generally reigns supreme, but there's these exemptions that exempt water rights holders from using their full beneficial use. And they could include things like military service or inability to access water due to drought or some sort of natural disaster, or enrollment in a federal program. So that's an important one, like the CREP program or something. There can be exemptions from using your water right. So taking a look at those can be important. I do think it's really worth doing some research on your own before you try to get an expensive attorney. But if you do feel like, oh, I really, this is a very complicated situation, there's certainly consultants and attorneys that can take a look at it for you and help guide you through the process. So hard to advise on exactly when that is, but I would say the basic research, you could certainly do on your own.
Let's see. Ashley's asking, where is it possible to find those exemptions? Are they, because you mentioned they're sort of state by state. What's a good place to go to learn more about exemptions?
For Washington, where is Ashley located?
I can't remember. She was asking about Idaho earlier, so that's
okay.
Potentially.
Yeah,
I'm based in Washington.
Okay.
Oh, great. Okay, so RCW 9014 will have the list of exemptions. I don't know the statute for Idaho, so you can take a look, and that's actually pretty straightforward to review. There's 21 or something of them, and it's just a long list, and you think, does this apply? Most of the time they don't apply, but occasionally they do. Okay, so it's worth taking a look and asking. Yeah.
So again, that's RCW 9014 for Washington. So that's a state statute, I'm assuming.
Yeah.
Let me check out some of these additional questions and see what would make sense for right now.
Okay. Shall we move on to the next section and then ask more questions, or?
Let me just see if anyone additional one should really be asked right now. I guess this one specific question that relates to what we were just talking about in terms of consumptive use and different things is Diane Chaplin's asking, how does the return water relate to tailwater?
Yeah,
probably come off mute if you need it.
It's often used. It's also two terms that are used interchangeably often. So the tailwater is the end of the water of the ditch. Return flows, I guess, is a little bit more broad in that you could also include the water that seeps out of the ditch into the stream. So tailwater is like the end of your ditch system, at the end of the system where there's a little bit of water, hopefully not a lot, but a little bit. And return flows, I guess, is a bit broader, sometimes used interchangeably, but the return flows is also stuff that seeps in through the ground and goes into the aquifer or into the river or stream.
We can return to some of these questions.
Cool.
Later on. Thanks.
Mm-hmm. Okay, so if you don't have a water right, or you have insufficient water rights, right? So maybe there's water rights on part of the property and not the whole property. We want to kind of just go over a survey here of potential opportunities for meeting irrigation demand. And so I'll just mention a few of them. Ashley and others on the call, I'm sure, are also experts on these. So feel free to bring up your experience if you'd like to share. But okay, so storage is certainly one option. And so small scale stored water really is dependent on your location and whether you have a permit for this. But there's certainly rainwater collection. I know you all did a full workshop on this, but generally rainwater can be used to meet small needs. It's meeting the needs of a large farm or irrigating a lot is hard to do with rainwater because you just can't store enough. And the storage systems, the cisterns, et cetera, are really expensive. And there are different rainwater statutes and what limitations on what you can and cannot store, depending on the state. But you know, I guess the thing to know here is that it can help meet kind of a portion of the need, but certainly as could be expensive at larger scales. Other options include recycled or reclaimed water, which means treated wastewater that has been cleaned or purified to a state that is appropriate either for drinking water standard or for irrigation standard, and can be used on a field. And so this is obviously only works if you have access to reclaimed water, and it's only in sort of where there's what we call sometimes purple pipe that's accessible. You know, the Sammamish Valley is one example in Washington where there is access to recycled or reclaimed water, but not that many areas have it. There are a few, and in some cases there are opportunities to connect folks to using that water. There also may be some limited opportunities for new water rights or water right transfers. And generally applying for a new water right is not always viable, but given the over-allocated nature of so many river systems, as we talked about at the very beginning of this, in that most rivers and aquifers are over-allocated, but there may be systems, and there's certainly areas where they're not, and there may be some availability. So it's worth checking with the state agency of whether or not it's possible to apply for a new water right. The existence of in-stream flow rules can also impact whether water is available for new uses. Water right transfers, also known as like water right leases, water right purchases, are an option in some cases. So in areas where there's a lot of irrigation, you could look into buying a water right and transferring it to a property that needed water. Generally, you can do that from upstream to downstream, but not the other way around. Although there are some exceptions to this, but generally you'd want to look upstream of you to find if somebody's willing to sell a water right and then transfer it. That kind of change is going to require a application and approval by the State Water Management Agency, but it's certainly happening, and there are water right transfers that are occurring. Certainly surface to groundwater swap. So this means like you're pumping out of a stream, but you actually would rather use a well for whatever reason. Maybe it's hard to get into the river to get your pump set up. That's also possible, but again, you have to work with the state agency to make that change. It can't just be made, there can't be a de facto change like that. And depending on the state, there are various legal considerations that make this difficult. There was a recent Supreme Court decision called the Foster decision in Washington, which makes this pretty difficult to do, but not entirely impossible. So it's worth considering. Exempt wells. So exempt wells are, you know, if we think back to the establishment of the water codes in the Western states, those were meant to set up this permit system for water uses of a certain scale. And usually it was for agriculture or for mining or these kind of commercial industrial operations. They also knew that people were settling across the Western US, and they had homes in rural areas, and they didn't have access to potable water from a municipal source. So all of the Western states generally have some kind of domestic exemption, which means it's exempt from permitting, but not always exempt from regulation. And there may be requirements, but generally in Washington, and you can use a domestic well for 5,000 gallons per day. And that includes also, you can irrigate up to half an acre. You could also use 5,000 gallons a day for stock watering and domestic use. In Oregon, it's 15,000 gallons per day and up to a half an acre of non-commercial lawn or garden. California, 2 acre feet per year, although I think there's some different provisions in areas under the SGMA, the Sustainable Groundwater Management Act. And depending on what basin you're in, there may be additional requirements. but you can use up to the 2 acre feet per year. So exempt wells are not necessarily an end-all solution. There certainly are a lot of small-scale farmers that are depending on exempt wells for irrigating. A half acre or less than an acre, that's happening. But it's in a lot of cases, it's kind of a last case resort for getting water for small scale farms.
Amanda, I'll just add a little nuance on the Oregon piece of that there. We have found out that a couple of years ago, Oregon Water Resources Department got some more resources to do enforcement of these exempt wells. And we were finding out through a lot of great work from Friends of Family Farmers, an awesome organization, if you're not familiar with it, that there were a lot of small scale growers that were using exempt wells for commercial gardens, not non-commercial gardens, and therefore were subject to various issues associated with that illegal use. And so right now, in the current state legislature, Friends of Family Farmers is advocating for this being changed. So I've shared some resources in the chat that they have really great background resources for people to learn a little bit more that I feel like are really well geared towards small scale producers and the people who serve them. So I know Sylvia is here from Friends of Family Farmers, even if that's not her area that she's really focused on, but thank you for all that work.
Yeah, any updates on that bill that Sylvia wants to?
The last that I saw, it's moving forward.
Okay.
Yeah.
Okay. Yeah, that would be unique. And I'm sure other states might look to it if it goes through. Thanks. Any questions on exempt wells? Other options, there's the purchase of water, right? Farms that are close to cities or adjacent to the cities and have access to municipal water can certainly use drinking water. The prohibition here is that it's quite expensive, right? I mean, depending on the city. In some cases, it's not as expensive, but most generally, it's you're not used to paying for water if you're using a well or a surface water right. So paying for municipal drinking water can be expensive. But certainly for high value crops or small scale operations, it can be a good fit. There's trucked water is an option happening in a few places around the West, even more expensive. And if you can only truck so much water, and then you generally need some kind of storage, whether that's a reservoir, a pond, or a cistern, more like it, given the scale. But they're options worth considering. Okay, so also a lot of on-farm solutions, and Dry Farming Project is all about this and has a ton of resources for on-farm water retention practices, but they're not to be underestimated, right? There's tons of practices related to shade and cooling and soil health management and increasing efficiencies with making the small amount of water that might be available go further. And so Ashley's an expert here, but I think it's worth calling out that all of these practices are helpful in water short areas, or as we're seeing increasing need and longer growing seasons and hotter growing seasons, and the need to stretch water further. Anything to add here, Ashley?
No, I'd just say Amy is also here from Dry Farming Institute. She's our real in-house expert, and we've got a lot of resources on our website.
Awesome. Okay, I think it's worth mentioning watershed planning, and that watershed planning is happening across the West, particularly Oregon, Washington, California. There's a ton of watershed planning, right? And so that involves writing watershed plans at the watershed scale that address water issues, and that could be water quality or water quantity, like we're talking about here today. And I think Ashley had asked me about this. Is there an opportunity to advocate for access to water? I think there's probably limited opportunities for advocacy in these realms, but certainly if there's an area where there's a real water need or water shortage, or there's something that's been identified, exploring whether that's part of the conversation in these forums could be a really good use of time. I have certainly seen some focus on water supply for local food and specialty crops, and kind of high value market crops. I think one example is the King County Local Food Initiative, which has really prioritized increasing the number of farmers and increasing access to food nearby a big urban area, and trying to support small farmers growing kind of high value market crops. And I'm sure there are other examples of that too. I guess a word of caution here is there's a ton of watershed planning going on. So if there's not if it's not the table might not always be talking about water quantity and water access. And so figuring out where the conversations are happening is important, so that you could waste all your time going to watershed planning meetings. Yeah, other thoughts from Ashley or others on this topic broadly?
I mean, broadly, I guess in Oregon, we've got a lot of watershed councils, which are always good, places to begin to build partnerships and conversations around these topics. We do have a really specific question about the Whatcom County adjudication process. I don't know when
Sure.
that makes sense or if it does. Yeah. So Katie asked, in Washington State Whatcom County adjudication process, does it seem likely that they would do away with any of the following: 5,000 gallons per day use for all without water rights, unlimited water use for livestock, and unlimited availability to drill a groundwater well for private use? That's getting pretty specific.
Yeah, it's a good question. So yeah, the Washington State hasn't done an adjudication for a long time. In fact, they were doing the Yakima. That took 30 years, and that wrapped up, 5 years ago or something. And then they've just started on this Nooksack Whatcom County adjudication.
Did you just say 30 years?
Yeah.
Okay.
Adjudication is no joke. They're aiming to finish Nooksack Whatcom before in a shorter amount of time. But this is people make a career out of it. It is. Yakima is big, and it took a very long time to get everything processed. It's a good question. What I know they're looking at surface water and groundwater. I don't know the answer to your question of whether it's likely that there would be any changes made there. I think it's certainly possible that there could be. And you might want to just kind of track the process or register your particular concern. I know that Ecology has tried to put a lot of resources into outreach, and there are people you could actually just call and ask that question that are focused just on this issue. So we could try to grab those names for you, unless you probably already have them if you're tracking it. But yeah, I think Robin McPherson. And then there's another person on outreach, I can't recall their name, but worth reaching out to them directly on that. A lot of the impetus for that adjudication was to address a lot of unauthorized diversions, particularly for berries in the area. There were a lot of water use that was not actually recognized by the state. So they're having to grapple with that, as well as rights for Nooksack and Lummi tribes there. So yeah, it's complicated, as you well know.
Let's see, we've got Trevor raising a hand. Go ahead, Trevor.
Thanks. I just had another question. I'm up in Whatcom, and I was wondering if, I had asked like legal injury to water rights. Is exempt well ever considered as far as how many exempt wells can be added to a region before you start to see legal injury for people's groundwater rights?
Yes.
And how
Yes.
does that happen?
Well, it's a cumulative impact kind of thing, right? And Washington State has recognized that as legal injury in several cases. and has set up required mitigation for permit exempt uses in some basins. So, for example, in the Dungeness Basin over on the Olympic Peninsula or in the Upper Kittitas Basin, exempt wells have to obtain mitigation before they can actually be put to use, any kind of new exempt well. And that's been the case for the last decade. So the premise for requiring them to get mitigation is that the state recognize that those exempt wells have an impact on existing senior water rights as well as in-stream flows. So yeah, that is certainly, Washington is probably the most proactive on that front, although there's some talk of it in other places. But in terms of recognizing exempt well impact on water resources, and they certainly do take that into account.
Thanks.
Thanks. Let's see, just continuing on that exempt well kind of topic really quickly. I just want to get some clarity. There's a question here on what I'm losing here. It says, Jeremy's asking, Washington State already has a half-acre exemption for commercial crops, which is that accurate, Amanda?
Yes,
Okay.
yes.
And they're just asking, how does this work? I think
If you have an
Oregon's different.
exempt well that is not subject to mitigation. So like you can't go drill a new well in the Dungeness or the Kittitas and get that exemption. It's usually for existing wells or wells in other basins. So there are some nuances to that. It's not across the board.
Great. And there's some other questions, but I don't know if you had other
I just
slides
have,
before
I
we
think
get
let's
there.
go to the questions because before we
Okay.
kind of go to the takeaways here.
Great.
Yeah.
And finally, I'm surprised it took this long, but we got to the topic of ponds and digging out small ponds, and if that's basically legal for them to dig out a small pond to collect water to use for irrigation or watering livestock.
Yeah, I would say that if a pond is being constructed for water storage and this, like the source is either surface water or groundwater, and they're not solely relying on rainwater, then it likely requires a permit and consultation with the state agency because it alters the hydrology of the area. So there's not an across the board answer here, but it usually would require a permit.
That makes sense. And I know there are definitely some resources that came up on our last rainwater collection session where this topic came up, and NRCS is definitely also a resource in this space. Typically, I know, they're being hit with staffing cuts and things like that, but they are another resource there to think about sort of engineering impacts. But I do think it's important to not only, there's this interesting tension between wanting to support small farmers and also looking at the watershed scale to make sure that, we're all trying to figure out how to share water and save water for the environment and all of these different things. So it's a constant sort of,
Yeah,
need to look at those things. Yeah.
Yeah. I mean, it does, if new farms are looking to start up, it really behooves them to look at property that already has access to water and already has access to water rights. And setting up in an irrigation district, for example, could be a really good fit. So I know the cost of land is often a big factor, but also access to water is another big consideration, I think.
Yeah, and just the realities that particularly in these three states, new property with water rights is just, as you mentioned, somewhat prohibitively expensive. So folks are looking at other solutions like municipal water if it's possible, or other dry farming, different things like that. I'm just looking through some of these questions to make sure we haven't missed any yet. I think there was a little bit of a clarifying question in terms of water rights. The question is, does the rate limitation specify the maximum amount of water that can be used at any given time, or can it be an average rate over time, like per day? And then
It's usually a maximum amount I guess there could be instances where it would specify that it's an average, but usually you can't exceed this many gallons per minute or this many CFS.
Okay. And then what happens to a surface water right if a stream jumps course? Does the point of diversion move with the stream? It's a
Yeah,
tricky
I
one.
think that's would be considered like a de facto point of diversion change. Yeah, I mean that's uncontrollable usually by the landowner. So it's still the same name, right? So it's still Catherine Creek or um, the Snoqualmie River. It's just in a different location, and obviously rivers and streams change all the time. So yeah, that it can be a pain in the butt to change your point of diversion, but it certainly is required. Yeah.
And then we've got Ashley with the raised hand. Go ahead.
So this is just in regards to a property kind of, I was a volunteer but was brought in to support the board with it. They acquired an old property that was like a boys camp, for instance, back in the 50s or 60s. Not sure how long it was in use or not, but basically when the people decided to sell it, there was like a deed or a trust that they had to continue using it for community, like open. It has to be open to the community. It can't be like sold or diverted into different things. But one of the things that I noticed when I walked the property with them, because they're new to all of this, it's a nonprofit that's purchased it. It looks like it was a wetland that was changed to be agriculture at one point. So there's old irrigation systems on it. But they're interested in wanting to do wetland restoration, but then also have some small like producer kind of aspects of there. Are there any resources that you'd recommend for like a split on like a property like that? I think it's about 30 acres.
So they want to do some wetland, and what was the other use?
Just like they want to have like a community garden and things like that, like small, because they have to have it open to the community. It's like a family, like
Mm.
a family and front kids kind of like space, but it's their long-term planning. But I'm just saying, like the wetlands looks like it's still naturally there, but could use some help. And I just wasn't sure if that changes kind of like the water right uses.
I don't know. I don't think that having the existence of the wetlands on the property would change the water right use. Probably there's already a well or they're hooked up to a city system for water, and that could be used for a small community garden, likely. But I don't think the presence of like having wetlands on the property would change the access to water for the other potential uses.
Awesome. Thank you for that.
Mhm.
Thank you so much, Amanda, for navigating all of these different questions coming from, different places of specificity. I think we've covered most of the questions so far.
Okay.
If anybody else has any additional questions or feels like we didn't answer something, please feel free to raise your hand or type in the chat.
Okay. While you think about that, I'll kind of go to my wrap up slide here.
Great.
Yeah, so in terms of key takeaways from the workshop, I think there are really a lot of difficulties with researching water rights, but I think it's behooves us all to just take a look at the water right, look at the parcel boundaries, look at the aerial photos, and ask those questions of the landowner or the neighbors to better understand it. So don't be intimidated if you kind of feel like you lack the understanding. Go ahead and seek out either agency personnel or someone else you know in the area that knows more about water rights. Ashley mentioned NRCS can be a resource as well. And other important information to know is that there's the information on the certificate, and then there's the information about the beneficial use, which you're going to gather from the history and your due diligence and the neighbors and others. So I think it's important to at least do the due diligence and think about what it is you want to do with the water right? And the example we just heard is, we're changing uses, but think about the what happened with the water right before and what might happen after. So there are lots of options for changing your water right and managing water rights. There's options of folks that can be the resources for future use. And I think land and water in the West really go hand in hand. We talked about the appurtenancy of water rights, and I think, and that's a fancy word, right? For water rights are connected to land, and you need to think about that if you don't sever a water right from the land, it's coming with the land, right? So generally, when you're working with landowners and you're thinking about how to work with water rights, you're going to want to go through your due diligence steps, and you're going to want to understand what happened before and after. And even if, like we had that question about what happened with a landowner that's deceased. There are opportunities for understanding more about that water, even if you can't talk to the previous landowner. And aerial photography tells you a lot, as does the record keeping. So I know that was a lot and sometimes a little scattershot. So I really do welcome any questions or thoughts. And I think we have a few more minutes here if folks have questions. Thanks so much.
Thank you. Thank you so much, Amanda. We do have one request. If you could go back to the slides for the landowner interview questions. Because that was a really good one. And yes, we will be sharing the slides with folks afterwards, as well as the recording. And Melissa, if you're able to share the evaluation just as we're wrapping up here, that would be great. As folks know, that's really helpful to us to make sure that we're dialing in the work that we're doing and always improving. So these are some of those great questions. I thought this was really helpful, Amanda, these questions.
Yeah, and I mean, it doesn't hurt to even print these out and take them with you, and you don't have to read them off, but just keep them in mind. Or follow up later on email or phone call, whatever works well for your landowners.
Yeah, and I think that history of use is always so important, not just to figuring out the water rights, but to understanding, soil health and what needs to happen there too.
Yeah, good point.
Do folks have any additional questions? Feel free to raise your hand or type them in the chat. Monica, would you feel like coming off mute to ask your question? It's always nice to see the humans in the space when possible.
Yeah, can you hear me okay?
Yeah, there is a little echo. So maybe try once more, and if not, I'll go ahead and read it out loud.
Does that work?
That's great. Yeah.
Okay. Yeah, I was just wondering, so once we identify that we have a valid water right, what are best practices for documenting maintenance of that water right or appropriate use of it? Like what level of detail is needed or sufficient?
Yeah, great question. I didn't cover that. But yes, once you know that your landowner has a water right or you have a water right, it's helpful to keep track of crop records or water use records. Like if you have a meter on your well or your point or your pump on the stream, it would be great to sort of keep records of that. And when you turn the pump on, how much you used, how much you used annually. So any kind of water use records you can keep, as well as like the specific acres or the total number of acres that were irrigated each year and with which crop. And like handwritten notes, typed notes, any format works.
Okay, great. Thank you.
Thanks for a good question. Record keeping and farmers always a challenging topic.
Not the most fun part here.
No. Does anyone have any additional questions? We covered so much here. I'd been really intimidated to try to tackle the question of water rights across all 3 states, but I think you did an absolutely fantastic job, Amanda, of outlining it all. And thank you all for your questions. We had a lot of question and conversation in the chat, which I thought was great to see, probably more so than we've had in other workshops. And I think with that, we can close the call unless there's any final questions. We've got a lot of big thank yous coming through.
And if anybody wants to stay on to ask a specific question or anything, I have more time, so we can do that too.
Yeah, we have a little extra time, which is always a great thing. And we've got one more question about, will the whole presentation be provided or just the visuals? And I think we'll do our best to share what we can of that presentation. Yeah. Well, thank you all so much for your time. Feel free to log off and feel free to stay on if you have any additional specific questions, since Amanda's being generous with her knowledge here and able to answer some questions. A lot of big thank yous coming through the chat.
I do see the question from
Yep.
Jordan about CREP
Mhm.
and permanent easement, conservation easements. Yes, and I don't know how it works in each state, but in some states there's water right is protected from forfeiture if it's enrolled in, like if a pertinent property is enrolled in the CREP program. Is as far as like usually a conservation easement in the language, it's a good idea to address the water right. So if you're working with a conservation easement, I think you can there's lots of examples of language that you can put into that easement that relates to the water right. Like it can only be used for agriculture, or it could be available for agricultural or environmental purposes. Or maybe it's the responsibility of the landowner to keep the water right in good standing and beneficially use it. So there's certainly different sort of angles you can take there.
You see this question from Sierra there in the chat?
If due diligence indicates that a water right has not been used in the last 5 years, what happens? Does the landowner have any options whatsoever to access it again? The answer is sorry, it depends. Kara, it depends on the situation. If it hasn't been used, you want to check and see if any of the exemptions to non-use apply, and figure out if there's any of them that apply, right? Was the property enrolled in CREP? Was there some reason why the person couldn't access? I was trying to bring up the list of exemptions here in Washington. So you can kind of go through that list of exemptions in case one of them applies. Certainly water rights do get resurrected after a period of not using it for 5 years, but it can be a bit risky. Like a neighbor might say, oh, wait a minute, my well's dropping now that you just turned yours on. You haven't used it for 10 years. That can happen. I will paste 9014-140 into the chat here if I can. But and that has the list of sufficient causes for non-use in Washington. There we go. So yeah, it really depends, I guess, on the situation. But it's worth really exploring to figure out if any of those sufficient causes for non-use that are on that link I just sent would apply.
Thanks. And then we've got a really specific rainwater collection question there from Kevin.
Oh, existing structure. And maybe somebody else also wants, maybe Melissa or Ashley want to weigh in on this, but existing structure generally, like you couldn't just build a whole bunch of parking lots or a whole bunch of roofs to collect rainwater for that sole purpose. But if you have a barn and you're collecting water off of that barn, then that's encouraged. But it's just, they're trying to discourage folks from just building structures for the purposes of, or creating impervious surface for the purpose of collecting additional rainwater.
That's my understanding for Oregon as well.
Cool.
Any other questions, or Melissa, if you had anything else to add around the rainwater collection piece?
I don't. I think Amanda summed that up great.
Nice.
I'm curious. I'm going to go back to this is Diane speaking. I want to go back to just my tailwater versus return water question. And part of the reason is I'm trying to figure out the terminology that's used to identify overuse or waste of water versus just kind of a catch and delivery system like some of the creeks and whatnot are used in our irrigation district.
Okay, remind me where you're located.
I'm in Southern Oregon, so we're in the Talent Irrigation District. And so that's Meyer Creek and Bear Creek, is part of a catch and delivery system, but there's also a lot of flood irrigation, which isn't always done. I mean, flood irrigation is inherently inefficient compared to other systems, but there are also more and less efficient ways to use flood irrigation with the topography of the land and how people manage their ditches. So if somebody is over irrigating because they're just waiting for water to get from point A to the polar opposite side of their field at point B, but because there are so many changes in topography over time that have happened, the water takes an incredibly long time to get there. But that's what they're using to determine when they tell the district ditch writer that they're done irrigating. It creates a lot of what we've been referring to as tailwater. So I'm just curious to know if any of those terms are used more in a context of waste or not, if there's a distinction.
Yeah, I mean, I don't think that would be considered waste if they're using an inefficient system. But if they need more water to get to, the far-flung reaches of their fields, and there's no other way to do it, then that's still, and they're within the water right, then they're not wasting the water under the legal definition. Is the water master concerned or the ditch writer concerned that there's waste here?
Right. I mean, in terms of speaking with neighbors and trying to give them, I mean, I'm certainly no irrigation expert, but just because I do both flood and sprinkler irrigation, there are a lot of properties in my area that are becoming more rural residential, where city
Yeah.
folks are coming and buying up properties and they have no clue how to use any of the systems or no clue how to water, no clue what to do with their fields. And so, as I help them to try to understand what the infrastructure would mean and responsible use would mean, they of course want to spend the least amount of money and put in the least amount of effort to meet the minimum requirements. And I'm thinking, well, can we think about this a little bit differently? So if you've got someone who has a field and they're flood irrigating it, and between point A and point B, which would be considered the furthest edge of the field they want to irrigate, a tractor's been running back and forth. So they've essentially created a ditch that the water doesn't get to point B because it's instead flowing in this ditch and then flowing onto a neighbor's property who's pissed off about it.
Mm-hmm.
Now their trees are dying because they're getting overwatered because that person didn't maintain, the field correctly, but is still just waiting for the water to get to the other side. So, I mean, obviously I waited till the end because this is a very specific question, but because I'm getting people asking me to walk their fields with them and help them try to figure out, and soil and water is a much better resource for this, but they can't always do that, or for whatever reason they want to reach out to me because they know me, and even if I say go to soil and water, they're like, well, Diane, can you just look at it first? So I just want to be able to give the best possible information.
Yeah, I mean, are they they're part of an irrigation district then?
Yeah, so they're paying for Talent Irrigation District water, but there are several properties in my neighborhood that have flipped from rural to rural residential, from production to rural residential. And folks
Yeah.
are not interested in being producers. They're happy to lease their land, or they're happy to just do whatever the minimum requirement is for them to maintain their EFU status if they have it, or to maintain their water right if they have one.
But the district is the one that maintains the water right? So I guess that's my question is what is the district saying about this?
And that's why I asked earlier in terms of what determines use. I don't think the district is monitoring. I don't think there's anybody in the district that's looking at aerial photos to see if they just don't have the bandwidth.
No. Well, I'm just saying the landowner's not necessarily at risk there because it's not an individual water right, it's the district's water right. So the district doesn't
So as long as you pay your water bill to the district, they don't care whether or not you use it. Your water right will remain with your property. So
yeah, I mean, it doesn't go, no,
let the field go fallow and never water it, and it wouldn't matter. He wouldn't lose the right.
I mean,
that's what he'd like to do. If he can just let it dry up and be a weed petri dish.
I think it's worth you talking to the irrigation district board and about how to address this situation so that you can advise all the all the newcomers that are in that area, because surely this is going to come up again. I mean, you certainly don't want to advise anyone that they just should run water out on their field to maintain water, right?
Yeah.
Yeah, this is really common across the West is that irrigation districts are turning into these rural residential areas. Another thing I work a lot on is in stream flow issues, and it's like that's that's really, you don't want to see kind of you want to see water going to actual agriculture and not to watering mega lawns or just kind of being wasted and evaporated. So um, yeah, it seems like it's worth it for you if you can just understand the district's perspective on this a little bit, and maybe there's another agricultural use that they could better use that water on than, somebody's uh, big backyard that's in a former irrigation district.
Mhm. Yeah, it's delicate because you don't want to call anybody out. You don't want to make anybody feel like a jerk for the decisions they're making because they just
No.
want to live in a pretty place. But yeah,
Yeah.
I get it a lot. Yeah.
Yeah,
For
and I
sure.
think you're not alone. There's just so much of that happening.
Mhm. Yeah, everywhere across the West. Adela's got a question
Oh, how
about
long? Okay,
Mhm.
Snohomish. I mean, I would say 6 months as fast as possible. Years is more like it, but
Yeah.
there are different ways to get there's these water conservancy boards that you can go through um, to process. I don't know if there's one that would be available there in Snohomish. I can't remember. Um, but there's different mechanisms. Like if you're willing to pay for the processing of your application, then it can go faster. But it's not fast. So there, like ecology, um, the the office that you would go out of is in Shoreline, and the Northwest Regional Office. It's worth just giving them a call if you have something in mind, and they can advise on it, um, and see about how long it would take for the change to happen.
I had a site visit with someone through NRCS and they wanted to see if they can apply for something. They had water rights, they were afraid of losing them because they hadn't used them for the last 4 years. And so they have this fifth year.
Hmm.
And they were also trying to see what they could do. We couldn't work with them because they needed to have at least 2 of the last 5 years irrigated. So the soonest we could help them with, it's the following year. But they told me a little bit about how they had applied for their rights years ago and that it took some time. I don't remember how much, and I was just kind of curious as to that timeline because that was the first time I really had a conversation about water rights with somebody who had acquired them and had them.
Well, another resource is somebody in Washington, if someone hasn't used their water for 4 years and they're afraid of losing it, is to donate into the Trust Water Rights program. And so you could contact Ecology about that, about a Trust Water Right donation, which would kind of like put a hold on the water right. Or you could contact the Washington Water Trust and they might be able to help you with that.
And I'll just say for folks who are still on the call from Oregon, I don't know like the specifics in terms of some of these things, but one of our farm partners I just found out was applying for a water right on a well, and it took several years to do that, and they couldn't use the water right in those 2 years according to that particular process, and it was pretty expensive. They're a dry farmer, and we're sort of doing other things on that particular property, so they could make it work to actually go through that long process, but again, that's just like one story. So, who knows all the different variations of that. But I was kind of shocked by that piece of it that it went, and they had no idea it was going to take that long, but it did take over 2 years.
Yeah. I've had them take longer, unfortunately. It can be really slow, but
Sure.
yeah.
Well, you've been very generous with your time, Amanda. Thank you so much. And I really appreciate folks staying on and listening. And I think this is kind of part of the interesting work is seeing the real situations that you all are dealing with and how varied they are and how to come up with some solutions. And I'll give a shameless plug for Addie Candib's coaching session that she did for our last water workshops, which are sort of trying to help fill this gap when you don't necessarily have the expertise or knowledge in a specific area, which happens to so many of you as farm service providers, there needs to be different ways of figuring out how to sort of ask questions and help the landowners help themselves. But this has been a nice, like, I think workshopping here with the last folks that have been left to kind of think through things. And that would be another cool kind of a workshop, just to have people bring their issues to the table and talk through them a little bit more. Wish we could do that, but not right now. With that, I think just thank you all so much for taking this time and being so present and asking your questions. And Amanda, again, amazing. It's really apparent your depth of knowledge, so thank you so much. And I'll let everyone sign off, and I'll probably stay on with our planning team folks. But
Thanks, everybody. Bye-bye.
thank you, thank you.
Thank you. Talk to you later. I'll send you I'll send you the PDF of my slides.
Great. Anything else before you need to
Stop
jump?
recording.
Yes.